Think of it. The hearing panel sustained the charge against me that I was fraudulent and therefore unworthy to practice medicine in the state of New York because I administered a vitamin. To quote the prosecutor, I don't care if it's injected or oral or rubbed onto the skin, it's irrelevant. And that amended charge was sustained by the panel as cause of revocation of my license. As I dictate this message, it is the dawn of a new year, 1993. I'm standing in my home, flushed with the joy of the holidays shared with my family, and I ask myself, is New York State serious? Is it really their intention to strip me of my license, my livelihood, my home, and all of my possessions after more than 35 years of practice on the basis of tainted testimony before a prejudiced set of inquisitors? Am I really important enough to justify the estimated $750,000 that they've invested already in this prolonged persecution? Whether I win or lose at this point, they have already succeeded in permanently damaging my personal and professional life that I have worked for all these years, and in negating my financial preparations for the future. With all of the pressures of this interminable harassment, they have simultaneously created a situation that precludes any reasonable physician from joining me in practice to fulfill my vision of the World Health Medical Group. I'm Dr. Warren Levin of New York City, and I'm sending you this communication to bring you up to date on the situation that threatens my practice and your business. I am certain that everyone listening to this tape is aware of the armed raid by the FDA on the office of my friend Jonathan Wright in the state of Washington, and the enormous impact that the popular outcry as a result had upon the proposed federal legislation on nutritional labeling. That demonstrates very clearly the power of the people. However, in my home state of New York, not everyone in the health food industry is aware of the state's efforts to squelch the nutritional approach to health. Since I am right now at the center of that cyclone, I felt that I should bring you up to date and tell you what I need you to do so that we can all continue to earn our living helping the great American public towards a healthier lifestyle. It's difficult to convey the entire story in a reasonable period of time. But for this targeted listening audience, the time spent, I think, will be of great interest and hopefully a valuable investment. I opened the first holistic center in the city of New York in 1974. It was in the garden level of my home in a brownstone in Brooklyn Heights. In 1979, I moved to the Wall Street area at the World Trade Center in an attempt to create the first center for executives as the World Health Medical Group. I was the first physician to administer intravenous chelation therapy in the state of New York, and still have supervised more chelation than any other New York practitioner. And for those of you who have been around a while, I'm proud to invoke the name of Carlton Fredericks as my personal mentor, friend, and godfather of my 6-year-old daughter, Erica. Now, I have been under investigation by the Office of Professional Medical Conduct. From now on, I'll call it the OPMC, since 1976. My first inkling of this was a subpoena that I received in 1980, which demanded that I turn over certain patient records to OPMC. They refused to tell me who had reported me and what the alleged complaint was about. And I felt that was unconstitutional, so I went to court, and I was successful in getting the subpoena quashed by the judge. That was the first step in a 6-year process, because the state appealed the verdict. They were upheld in the appellate division, but by a split decision, so we went to the Court of Appeals in Albany, where, in beautiful language, the court upheld my rights. They said there must be a threshold showing of the authenticity of a complaint as warranting investigation, and they said it is fitting that before the investigative engines of governmental agencies are started up against an individual, at least minimal warrant is shown for such an intrusion. Instead of providing me with the information, they waited 6 months, and then they issued the same subpoena again. And I was forced to go into court a second time over the same issue. And this time, over our serious objections, they presented the basis of their investigation to the judge in the privacy of his chambers, without me or my attorney being present. The judge found that they had adequate reason to investigate me, so he allowed the subpoena to stand. Once again, we appealed, and once again, we had to go all the way to the Court of Appeals in Albany, and this time, I lost. So, after about $50,000 and 6 years of fighting the government, I turned over my records. It took them another 3 years to bring me up on charges. But finally, in 1989, I was officially charged with negligence, gross negligence, incompetence, gross incompetence, and fraud for practicing complementary medicine, including glucose tolerance tests, vitamin and mineral tests and treatment, stool analysis, intravenous chelation therapy, and ultimately clinical ecology, the diagnosis of candida infection, and so on. Altogether, there were over 140 separate allegations of misconduct, many of which were repetitious for different patients, but all of them representative of my practice of orthomolecular complementary medicine. I have listed a synopsis of those charges on one of the enclosures. Please take careful notice that with all of the charges and allegations, there is not a single charge of any harm to any patient, and that's after 13 years of investigation. When we got to the hearings, we learned that the state had only one witness that they felt was qualified to testify against me. That is the self-anointed, self-appointed quackbuster of medicine, Dr. and lawyer Victor Herbert. Of course, I knew that Victor Herbert was a malicious demagogue who would stop at nothing to achieve his objective. So, with the help of my friends all over the country, I put together the evidence to show the judge that Victor Herbert had no business being in that hearing as my inquisitor. The result was that after 2 days of presenting our evidence about Victor Herbert to the hearing panel and the administrative law judge, the judge dismissed Herbert as being unfit to be an expert. One reason was that he said he had no prejudice with me, after which we produced the transcript of the hearings held by Congressman Claude Pepper in investigation of so-called health fraud, where Herbert had named me 5 times as practicing questionable medicine. And we also produced a copy of an editorial he had written in the New York State Medical Journal, in which he had bragged about reporting physicians who practiced questionable medicine to the Office of Professional Medical Conduct. But the final straw was when my attorney, Robert Harris of Woodmere, New York, specifically asked Herbert whether he had reported me to the OPMC, pointing out that if he was both the complainant and the expert witness, it was important that the hearing committee be aware of that. The state's attorney advised him not to answer the question, and he refused to do that. Well, I was not aware, and perhaps you are not either, but an expert witness is not entitled to the legal counsel of the prosecuting attorney. However, you can be sure that Victor Herbert knew that because he's a lawyer, and you can be sure that the state's attorney knew it as well. And Mr. Harris pointed it out immediately as indicative of what he called the incestuous nature of the relationship between the Department of Health and this expert witness. The judge called a recess, and when we reconvened a week later, the judge read a beautiful 3-page legal decision based upon his interpretation of the law in question, which provides confidentiality to people who submit complaints to the Medical Board of Inquiry. And it was his ruling that under these circumstances, that confidentiality had to be waived, and he explained to Victor Herbert that although he was not qualified to hold him in contempt of court, that if he refused to answer the question, he would be dismissed as a witness. And Herbert again refused on the advice of counsel, and he was thrown out. The hearing committee had heard no evidence against me, and the state said that they didn't have another witness who was qualified to testify. So the hearing panel made a recommendation that all the charges be dropped. And it was at that point that the next serious breach of my constitutional rights took place, because the panel's recommendation was reviewed by the Commissioner of Health, at that time Dr. David Axelrod. He is a doctor, not a lawyer. But he overturned the judge's legal determination that Herbert was unfit to be a witness, and he remanded me back into the hearings with the same panel, the same judge, and Victor Herbert as the expert witness.